Let's get on record.
You're on record?
Okay, today is the day set for the Office of Hearings and Appeals to determine whether or not the respondent, Christopher Deschene, is eligible to run for office of Navajo Nation President pursuant to the directive of Navajo Nation Supreme Court. The OHA implements the standards set by them in determining whether or not he is fluent in Navajo. So, got the written opinion from the Navajo Nation Supreme Court yesterday. This is the written opinion that was that they told us back a week ago when we were all into the city. And I trust counsel for all parties got a copy of this Supreme Court order?
Yes, sir.
Yes, sir. All right, for the record, let's go around the table and introduce yourselves. Starting with you.
Brian Lewis for Chris Deschene.
Okay.
David Jordan for Dale Tsosie.
Sept Deschene, Justin Jones, legal counsel for Tsosie and Whitethorne.
Good day, Dale Tsosie.
Hank Whitethorne.
Any other legal counsel that should be recognized?
Sandra Taylor, David Jordan's office.
Okay.
For Dale Tsosie.
And the two ladies in the back?
Lydia Fast Force, the Navajo language expert, Mr. Jordan.
And you?
Charlotte Tsosie.
And your
Or
role here?
Dale Tsosie.
Okay. All right, let's go over here.
Martha Nashville, present this. Can't hear you.
Okay. Do we need to introduce people in the back? Just for the record, let's start with my staff.
Trudy Arvino, Legal Secretary, Office of Hearing and Appeals.
I'm Mariana Khan, Office of Legislative Counsel.
Paul Spruan, Department of Justice.
Lenore Fulton, Navajo Board of Protection Supervisor.
And behind you?
Good morning, I'm Stan Milford Jr. with the Navajo Nation Rangers, the Sergeant.
Good morning, my name is Victoria Dixon. I work with the Labor Commission. I'm a legislative reporter.
Yat e bene Marley Shabala yin shia tohe glini stone as at the emphasis chief.
Flora Brand, Navajo Nation Officer of Broadcast Services.
Christina Tsosie, Office of Broadcast Services.
Okay, and with me here is Joe Aguirre. He's the other hearing officer with the Office of Hearings and Appeals. As well, we have Meredith Benali. She's the administrative assistant and a reporter for today's hearing. A couple of days ago, I got together with council, and we talked over the procedure and how we're going to conduct this hearing. And both council have decided to waive opening statements in this case. I think the Supreme Court has pretty much given, I would say, the instructions on what to decide. So we will do that. So what we will do now is there was a deposition of Mr. Deschene, and the parties, only the parties, the legal counsel, and the petitioners under counsel respond to under counsel. Will be permitted to view this deposition. After the deposition is over, people will be invited back in, and then we can get on with the rest of the hearing. Okay? So it's for those of you who are not parties to the case or are not legal counsel, we will kindly excuse you at this time.
Stop streaming.
Let's get back on record.
You're back on record.
All right. So the parties have we have seen the video depositions of Mr. Chris Deschene. Burden now is on the petitioners clear and convincing evidence in their case. Proceed, Councilman.
Thank you, Judge. We call the first witness, Chris Deschene.
Mr. Deschene, would you please raise your right hand, sir? Say your full name.
Christopher Deschene.
You swear to tell the truth, the whole truth, and nothing but truth at this proceeding, sir?
Yes, Your Honor.
Thank you, Your Honor. The witness counsel.
Mr. Jones will examine him first.
Mr. Jones?
Hey, Mr. Deschene. Chairman, this is one thing that we ran into over at the position is the fact that we're not objecting to the translator translating to the attorney, that's fine. But when the translation becomes so loud that the person that's the subject here hears that, then that kind of defeats the purpose. And I believe that that's what's happening again here. And how can we take care of that?
I believe that this is I'll just take judicial notice that most proceedings, if not all proceedings, in the various courts of the Navajo Nation, including administrative courts, are done in English. And if it's not in English, then either side has a right to interpretation. So I will grant the interpretation. And although this is a unique proceeding where everybody is supposed to find out whether or not Navajo fluency is established, I take notice that the respondent's legal counsel is not Navajo, and so he is entitled to interpretation of your questions. Proceed. Well, I did not hear interpretation. Mr. Jones, I did not hear it. So I will take your word and caution the interpreter that, yes, interpret, but not so loud that it will be a distraction. Proceed.
Yeah. Mr. Deschene.
Let me just say for the record, as I have protested many times, that this is an unfair standard. This standard was devised by you and Mr. Whitethorne. That this standard in its application is wrong. That you represent a client that missed an opportunity, that has somehow convinced you and the larger body, the Supreme Court, to say that we are going to administer a test that has never been given before in the entire history and universe of the Navajo Nation. So I protest and I object to your questioning.
No, sure. Mr. Deschene, can you describe in the Navajo Nation government in the Navajo language, using the Navajo language, without inserting English language anywhere in there, can you describe to me how a resolution becomes law? It's a yes or no question. Can you describe to me?
Mr. Chair, we deserve a substantive answer. Everybody keeps talking about our burden of proof, and Mr. Deschene seems to think that he could just refuse to answer all our questions and then say we haven't met our burden of proof at the end. We deserve a substantive answer. He's asking in English, do you have the ability to say it, yes or no? Mr. Deschene knows the answer in his head to that question. He either can say it or he can't. Say yes or no. He can't even say it in English. But we deserve an answer to the question. And we're not going to go on to another question until we get an answer, yes or no.
The content of his answers are his own choosing and his free will, and he has the prerogative to answer them as he will. They have the ability to pose the questions to try to prove out their case, and then we will submit the evidence to you for a final ruling. You do not believe, I guess it's ultimately your view of whether you believe the questions and the answers are substantive enough for you to make a decision one way or the other. But the content of his answers, they are what they are. It is what it is, and there's no way for us to hold him down to force him to answer in a certain way or qualitatively more than we'd otherwise like.
Mr. Jordan?
In any other form, let's take the language aspect of this case, which is unique out of this. In any other form, if Mr. Jones asked a fair question and asked for a yes or no answer, and the witness just flat out refused to answer, which is what he's doing, he's just flat out refusing to answer, then the tribunal would tell him, you need to answer the question. You don't have the right to sit here and refuse to answer. He's been hauled in here by Navajo law, under the color of the law, under your authority. And because it's our duty, we have the right to ask him the questions that we believe are appropriate for meeting our burden of proof. For you to allow him to simply refuse to answer the questions is essentially saying, you know, we're going to ignore what the Supreme Court has said, we're going to ignore the entire authority of this tribunal, and make really a mockery of these proceedings. He's asking him in English, can you say this? This witness knows the answer. He does. He knows whether he can say it or not. He's just refusing to give it to you.
The question I hear is, can you describe how a resolution becomes law?
Right.
Is that a question, Mr. Jones?
In the Navajo language.
Can you describe how a resolution becomes law in the Navajo language?
Yes, sir.
Okay. And the response is?
He's testing me. It's not right. That is in English, for your understanding.
Now, Your Honor, your Judge, the Supreme Court yesterday issued a very specific ruling. And if you look on page 12, it specifically says that this Deschene shall cooperate with the OHA as it carries out its duty. What's it saying? Words of the Supreme Court. And it's very obvious right now that Deschene is not doing that.
It is not as though Mr. Deschene is simply refusing to be here or participate in any such manner. He's here, he's participating, but is this a test of his, I don't understand how this is going to ferret out his Navajo speaking skills as much as his knowledge of the legislative process or any other intellectual acumen type questions that could be asked here.
The Supreme Court said that in order for Office of Hearings and Appeals to pass on whether or not Mr. Deschene is fluent in the Navajo language, the Supreme Court has given me a standard to go by. Del Conco, Antadahinas, Lavo, Chumnapo, Ditsako. I illegal. It's like go by, that's just here. Nadiki, Yajiki, Itchin, Yajiki, Hachin, Ayaki, and the neck apple, is 18. That's the standard that I'm looking for. I get a hand as largo. I chumnako, it's a deep saddle. Why, I just killed. I just killed. But the question is, can you, Mr. Deschene, can you describe how a resolution becomes law in Navajo? And what is your response?
Your Honor, with all due respect, it's a test. He is not an expert. The test that he's applying has never been administered. With all due respect, Your Honor, it is not appropriate, it is not right. So he's administering a test. This test is a result of Mr. Justin Jones and Mr. Whitethorne. It is their test. The court has also stated that day we were in Tuba City, we will accept Mr. Whitethorne's standard. He is not an expert. He is a 15th place loser. So I respectfully decline to put myself in front of the whole world to answer a test that has not been vetted, not has been approved, not has been tested, that has not been standardized, and moreover, not been applied to other elected officials. If we were to apply the test that they want to have, it should incorporate the vetting process, Your Honor.
Response, Mr. Jones?
First and foremost, let me dispel something here. Again, every day across the Navajo Nation, there are thousands and thousands of Navajo students that are tested in the Navajo language, even simpler than this. So there's testing going on all the time. Number two, if you walk across over to this building over here, there's a Navajo language culture certification, and there's an agreement with the state of New Mexico and Arizona. So if a Diné teacher or even a non-Diné teacher wants to be certified by these respective states, they have to do a test as well. Just recently, the Navajo Technical University has a new program, the Navajo Language and Culture Master's Program. In either for a person to get that master's program, they have to go through an even harder and harder test. This is elementary. It's simple conversation. It's a simple set of knowledge that he's being asked. So thereby, I don't understand what the whole refusal is. I mean, if the bottom line here is that it's real simple, we can just put all of this to a close. If he just says, I cannot do it for the why is Mr. Deschene dragging this thing out? He's dragging it out. He's done that with all of the motions that he's tried to file. Then it should get it up and it should never get it up all for you. But really, it's the Navajo Nation Supreme Court. There's something very, very ethically wrong here. Again, as I've stated here, last Friday, Shanam, is that the Supreme Court ain't on this not ninda, or his need not ninda, di que hoto zinch, ki que ben dina, jo in do nin. Jo pe hoto zinch, do pa hoto zinch, ki kade to tan nadi. A konde e go his honor. We're not in a criminal proceeding. If he's under the idea that he's taking the fifth, there's no such thing here. He has to answer these questions. Period.
Fifth Amendment equal to the battle advantage neither. So he's not raising the Fifth Amendment, so that's not an issue.
Judge, if I may.
Mr. Wait,
Hold on a second.
Sorry,
One at a time. Go ahead,
to
Mr.
cut you
Lewis.
off, Mr. Jordan, but I have to respond to Mr. Jones on this. He's not being certified to become a teacher. He's not working to get a master's degree here. He's simply sitting as a witness in a hearing. He doesn't need to answer anything to overcome some sort of a test to be certified as a teacher, as an advanced student. The requirement in the law is designed to see if he can engage in a dialogue, if he can reciprocally communicate ideas back and forth as the president of the Navajo Nation. Not to teach young children, not to talk to people about civics, not to get a master's degree. He's sitting here, he's providing his answers. He doesn't like the questions posed to him. Obviously, I think that we can all see that. It's perhaps the questioner to him. But whatever the matter is, his answers can be considered by you to these questions, and on my redirect, with all of the weight of the evidence that Mr. Jordan's going to put forth, Mr. Jones, myself, the rebuttal case, and then at the end of the day, you can make a decision. But in terms of binding his arm, whether the questions are helpful or not is a different question, or the answers are helpful or not is a different question. But at least he's putting content here. He's not refusing to participate. He's not disobeying the order of the Supreme Court or this body. He's simply providing the answers that he wants in his own free will to questions that he does not see as appropriate, that frankly objects to the entirety of this whole process and being the only person in the history of the Navajo Nation to have been subjected to something like this. But nonetheless, it's still here, as is his duty, appearing before this body and listening to the questions asked and providing some sort of an answer, but answers that opposing counsel apparently does not have those answers. So it's for you to, I guess, hear them and make your determination at the end of the day.
Jordan, thank you, sir. We're really moving into a different area here, Judge. We're really moving into the authority of the Office of Hearings and Appeals and the authority of the Supreme Court. The Supreme Court ordered, and Mr. Jones is right, it's right here, Deschene shall cooperate with the OHA as it carries out its duties. That's the Supreme Court order. That's the authority of the Supreme Court. You asked them the direct question of your authority. Can you describe how a resolution becomes law in Navajo? He refused to answer your question. Now, when a petitioner has a burden of proof, they ask questions. They have a right to answer. If the answer is I don't know, then he should say I don't know. But we all know, everybody in this room knows that in his head he knows the answer to that question. He knows whether he can describe how a resolution becomes law. Now, if the answer is, look, it's not a Navajo, I just don't know how a resolution becomes law, well, he can say that. And then we can pose a different kind of question. We can ask him, you know, does he know how to go to law school in Navajo? Okay, I know he knows how to go to law school. But we're entitled to an answer to the questions that he knows the answer to in his head. For him to say, I refuse to answer, or, you know, I've never been tested before, and this is a test, and it's just a test, or even worse, that Hank Whitethorne is a loser, which is just a viciously mean thing to say. I mean, really, it's really uncalled for. All of that is just simply defying your authority and the Supreme Court's authority. He may not like the Supreme Court ruling. He may not like being here. He may not like the fact that the council's opposed to fluency requirement. But guess what? That's the law. And today, it's your job to enforce the law. So, I ask that it be posted that he either provides yes or no, honest yes or no answers or we renew our motion to default him and enter an order against him. Because what else can we do? If he's simply going to defy your authority and the Supreme Court's authority, to just flat out defy it, then there has to be consequences. You already refused to take the test, and you forgave him that. And we took the deposition. We all watched the deposition. It was painful to watch. He refused to answer question after question. This is your test, Justin. This is your test. You're not going to test me, he kept saying, over and over and over again. The name is Sept. All right? So he's Navajo. Good. But at some point, the authority of the Navajo tribunals has to kick in and say, I'm sorry, Mr. Deschene, you're going to have to answer this question. If you know the answer, and we know he does, you have to provide it. Or there will be consequences, and the consequence has to be he loses his case.
All right, so, by the direction and directive of the Navajo Nation Supreme Court, I will ask and I will require Mr. Deschene to answer that question. I know the response, but ask the question again, Mr. Jones.
In the Navajo language, can you describe to me, within the Navajo Nation government, how a resolution becomes law?
And in English, what did you say?
I said, you are testing me, and that is not right.
I ask that we give him one more chance to answer this question, and if he doesn't, and if he defies it one more time, that you enter a default right now, because otherwise he's just defying your authority.
Okay, ask the question again.
In the Navajo language, within the Navajo Nation government, can you describe how a resolution becomes law?
We move for default.
We object, we respond in opposition. We're here to hear this case out. If there are poor answers, if that's your determination, certainly opposing counsel's thought on this. And let's hear out the entirety of the case. There's a much different side of Mr. Deschene that this body will see when it will not pose a challenge from Mr. Jones. It may be just a personal rift between them. It may be that he doesn't want to respond to what he sees as the administration of an illegitimate test by a particular person. But we will provide Mr. Deschene that will speak Navajo to you this today in a rebuttal case. And we would ask that, having spent all the time to get here, all the resources, it is worthwhile for this body, and we would ask that you do go forth, hear out the entirety of the case for a day, and then make your determination at the end of the day.
They don't get to do it their way. They get to put on their case their way. That's true. When it's time for their case, they get to put it on their way. And I have to sit back and let them. But they don't get to tell us how to put on our case. It's a fair question. He's a presidential candidate. We're not asking him the Pythagorean theorem in Navajo. We're asking him how a resolution becomes law. That's a fair question for a Navajo presidential candidate. It's a fair question, and he has repeatedly defied your authority as you've directed him to answer the question. It is not Mr. Deschene versus Mr. Jones. It is not him versus me. It's not even before the Supreme Court. He has defined the authority of this tribunal. We cannot present our case if he continues to defy the authority of this tribunal.
All right. Is your answer, is your response, Mr. Deschene, going to be any different from what you have responded to me or responded to Mr. Jones?
Your Honor, this is an unfair testing. They can ask questions. They don't have a right to test me. That's the point, Your Honor. That's the hearing that they brought up. These are their actions. And I'm more than happy to show through my counsel in our case that I meet the standard judge. And Jones has been testing me, and he's not an expert. The standard is wrong, and the application of the standard is wrong. Nobody else is being forced to do this. Nobody is asked to certify like I have been tested. And it's a complete affront, not only to me, but to voters that selected me, so their voice is being ignored, as well as what their message is to our younger generation. So, I have given you an answer, Your Honor, and that is, he is testing me, and that's not right, Your Honor.
On October 3rd, I believe we were all in Tuba City, and we had oral arguments. You folks had oral arguments. I was in the gallery, and at that point, the Navajo Nation Supreme Court came down with a written order overruling my decision, and it's Supreme Court's prerogative to do that. And they sent me back here to the drawing room, if you will, and we sat down this past Monday. And this past Monday, I had asked for the assistance of the Navajo Diné Culture Program, or from the Diné Division of Education. And Dr. Ansita Benali was very, very helpful and professional, as was two of her staff. And I asked them for their assistance in devising a test. I know that they oversee a program that is approved in New Mexico, and they're going through approval in Arizona to certify now professionals in their teaching profession to teach Navajo to our children. But this was not for certification for teaching Navajo children, so we all understood that. And so I said, can you devise a test that will test Mr. Deschene and candidates in similar positions to see whether or not they are, he and other similar candidates in the future will be fluent in the Navajo language? And they said yes, they can. I talked with counsel here this past Monday, and everybody agreed at that time. Except for Mr. Lewis. But at the time, Mr. Lewis wasn't here as counsel. But his previous counsel agreed to it. And so we thought, okay, rather than bringing it to me solely as the person that will determine the future of Navajo voters and the future of Mr. Deschene, I wanted a panel that would be a little more objective to decide whether or not Mr. Deschene is fluent. Mr. Deschene's previous counsel was terminated. He withdrew, and Mr. Brian Lewis came in as new counsel. And at that time, the course of the trial changed. And there was no longer an agreement to have an independent panel of professionals passing on judgment over Mr. Deschene. We have viewed the depositions, and I have heard Mr. Deschine's objections on grounds of foundation, on grounds of vagueness, and on grounds that this is a test that has never been implemented or recognized. And we keep objecting on the ground that Mr. Jones's questions on depositions is that this is your test, Mr. Jones, and it is not a test that has never been administered. And today, as we start the proceedings, the same objections has been voiced by Mr. Deschene. I think I've been forced to the position that I will enter a default judgment against Mr. Deschene. You folks, Mr. Deschene, Mr. Brian Lewis, with all due respect, you have the right to appeal that to the Supreme Court. But in this case, I have no choice. I've been pushed to a corner that, I believe by clear and convincing evidence, by refusing to answer questions, which would lead me to pass on whether or not Mr. Deschene is fluent. You have not given me that opportunity. And so because you have not given me that opportunity, I have no choice but to enter the default. Scott Alfred.
Not record.
You got it.